So when we're talking about proprietary estoppel, this is a doctrine that can come up in different areas, for instance, in neighbour disputes, but I'm going to be focusing on it as a way of laying claim to assets which the claimant isn't already entitled to, or where they've got a lesser entitlement than they say they should have. And in particular, because the focus here is really the contentious probate arena, I'm talking here about claims where there's a promise that someone will pass on assets after their death. So the classic case is with a farm or a house or another kind of family business. It's usually one of those. The older generation, who is the owner of the asset, says something to the effect of, this will be yours when I'm gone, or sometimes it's more explicit than that, you will inherit this property. And then the claim arises when that expectation is frustrated, because either the legal owner has changed their mind, done something different, or they didn't implement what they were intending to do. For instance, if they were going to make a will but then never did, so died intestate, or if something else has gone unexpectedly wrong. I'm going to focus mainly on cases where the party making the promise is deceased. But quite a few of the proprietary estoppel cases we see reported do involve disputes which have arisen during the lifetime of the person who's given the assurances. Those often have further complications, because whereas they were intending to pass on assets, or they said they were planning to pass on assets after their death, and that usually assumes that everyone is getting on all right up until then. If the dispute's arisen while they're still alive, it may be that it's no longer possible for them to live and work together. And sorting out that unexpected situation can be really quite difficult. And we see that in some of the cases. One area which was in debate, but I think has more or less been settled, is formality requirements where it's one of those cases which is closer to a contractual bargain. Because we're usually talking about land, proprietary estoppel claims. Normally, with a contract for a transfer of an interest in land, it needs to comply with the requirements of the 1989 Act. Otherwise, it's an unenforceable contract. There was an argument that you shouldn't be able to use proprietary estoppel to get around this, to effectively enforce a contract that couldn't be a valid contract. It does now seem to be settled, at least at high court level, that proprietary estoppel claims are viable in these circumstances, and that they are not prevented by the 1989 Act, even if it looks pretty close to a contract. So I think that is the established law, at least until someone takes it to the Court of Appeal. So in summary on this, proprietary estoppel claims seldom need to be concerned about legal formality requirements. They are a way of doing justice between the parties where the formalities have not been followed.